Senate Committee on Criminal Justice come to order. The clerk will please call the roll.
Chair Flores,
Present.
Vice Chair Parker, Senator Hinojosa,
Present.
Senator Huffman, Senator Miles, Senator King, Senator Hagenboom.
A quorum has been established. This morning, we have about 23 bills to consider addressing issues ranging from sexual assault and deepfake technology to the crime of drugging. And so without delay, we're going to get to work. It is the intent of the chair to lay out the bills one at a time, take invited and public testimony, then vote on the bill in order of presentation. If you intend to provide verbal testimony or would like to register a position on one or more bills, please register at one of the kiosks located behind the committee room. Members, anyone have any statement you wish to make? If not, we will begin. But before I begin, I just want to say one thing, if I may, if you can. Director Collier, 40 years of service to the state. Congratulations to you. You've been a blessing to us all, and Texas is very blessed to have you. Chair lays out House Bill 47 and recognizes Senate sponsor Senator Zaffirini to explain the bill.
Thank you, Mr. Chairman, and thank you for the 7 a.m. hearing. I know we all appreciate it. I certainly do.
Well, you were probably up already anyway.
I love it. Actually, I'm not joking. I love
This is
it.
late for you.
It is. Mr. Chairman and members, House Bill 47 is by Representatives Donna Howard, Tom Oliverson, Lacey Hull, David Cook, Lulu Flores, Trey Martinez Fisher, and Mijaela Plesa. It was passed by the House unanimously and relates to sexual assault and other sex offenses. Of the 3 bills I have, this is the long one. House Bill 47 is the omnibus bill of the legislative recommendations from the Governor's Sexual Assault Survivors Task Force. In 2019, House Bill 1590 created the task force to develop a survivor-centered, trauma-informed response to sexual violence in Texas. Major gaps in current law, however, leave survivors vulnerable, including by allowing them to break a lease only if their assaults occurred at that property, allowing registered sex offenders to work as rideshare drivers, and requiring courts to consider the impact of case delays only on child sexual assault and family violence survivors, not on adult survivors. Equally concerning, beyond the initial forensic exam, survivors are not guaranteed adequate post-assault health care, including HIV tests, treatments for sexually transmitted infections, and prescriptions. Finally, sexual assault response teams are not required to report data to their county commissioners' courts, making it difficult to assess responses to sexual violence. This bill would enhance safety, strengthen legal protections, and ensure a more effective statewide response. Generally then, House Bill 47 would ensure courts consider the impact of case delays for adult survivors of sexual assault, expand post-assault health care to 30 days for follow-up care, expand training for healthcare workers regarding survivor care, prohibit persons on the state sex offender registry from working as rideshare drivers, require sexual assault response teams to report biannually, and allow lease termination regardless of where the sexual assault occurred. It's an important bill, and I certainly would hope for your support, too. Thank you, Mr. Chairman.
Members, any questions? Any questions? If not, the chair now opens for invited testimony. The chair calls Nicole Martinez. Good morning. For the record, your name, who you represent, and you may begin your testimony.
Thank you, Chair Flores and Vice Chair Parker and esteemed members of this committee. My name is Nicole Martinez, and I am the administrator for the Governor's Sexual Assault Survivors Task Force. As Senator Zaffirini mentioned, the task force was established in 2019 to develop policy recommendations to improve our state's response to sexual violence, including the prevention, investigation, and prosecution of sexual assault cases. The legislature also mandated us to make recommendations to improve the collection of reporting and collection of data on investigations and prosecutions of sexual assault. We were also asked to develop statewide standards for best practices And furthermore, we were required to submit a biennial report to the Texas Legislature outlining those policy recommendations and the statewide standards for best practices. The task force has developed whole survivor care guiding principles, and House Bill 47 includes 8 of the 10 policy recommendations that were included in our 2024 biennial report, to include recommendations around the whole survivor care guiding principles. I am here today as a resource witness and to answer any questions you may have about House Bill 47, the Sexual Assault Survivors Task Force's omnibus bill.
Thank you. Thank you for being here. Any questions, members? Any questions, members? Thank you. Thank Senator Vice Chair Parker.
Thank you. I just want to thank you for being here. Appreciate your leadership for the state and such a critically important item, and just thank you for being on top of it and being here today. So appreciate you very much. Thank you.
I appreciate all of you.
And show Vice Chair Parker is present. Thank you for your testimony.
Thank you.
With no more witnesses for invited testimony, invited testimony is closed. The chair now opens up for public testimony. Chair calls M. Page Williams. Good morning.
Good morning.
If you state your name, who you represent, your position on the bill, and you have 2 minutes.
Thank you, sir. My name is Paige Williams. I am here representing Dallas County Criminal District Attorney John Crusoe, and we are on the bill. Specifically, I would like to draw your attention to Section 15 and 16 of the bill, which is the reporting requirements. If you notice that Section 16 requires or mandates that governor's granting would be removed if the reporting requirements are not met in Section 15. And I just want to point out that the SART is a group of individuals who are not government employees, all of them. They come from hospitals, they come from police departments, they come from, some of them are volunteers as sexual assault survivors. So these individuals that sit on this committee or in this group that make these reports, which we have no problem with the reports. What we do have a problem with is that the grant funding for the county, if the report is not sufficient or doesn't meet requirements in any way, shape, or form, all grant funding for the county can be removed. So there's a little bit of heartburn there. The rest of the bill is absolutely excellent.
Well, thank you. Thank you for being here. Members, any questions? Thank you very much.
Thank you.
Thank you for being here.
The chair sees no one else registered for public testimony. Is anyone wishes to testify on, for, or against House Bill 47? Hearing none, public testimony is closed, and we'll leave the bill pending. Chair calls House Bill 171. The chair sends up the committee substitute for House Bill 171. Is there any objection to adopting the committee substitute for House Bill 171? Hearing none, so ordered. Recognize Senator Zaffarini to explain the bill and committee substitute.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 171 is by Representative Ryan Guillen. It relates to the Certificate of Medical Examination for Chemical Dependency and the duration of court-ordered treatment for a person with chemical dependency. House Bill 171 is named the Anel Borrego Act to honor the memory of our mutual constituent who died at 23 after years of short-term placements in drug rehabilitation facilities with no long-term support or continuity of care. Under current law, persons with chemical dependency may be subject to court-ordered treatment at an applicable facility for no more than 90 days, but they are not subject to treatment for a minimum number of days. This has resulted in short stays that may result in less effective treatment outcomes. Generally then, House Bill 171 would set a minimum duration for court-ordered treatment for qualifying persons with chemical dependency, but it would allow a patient to be discharged before a court order expires if the treating physician determines the patient no longer meets the criteria for continued treatment, and it updates references to the appropriate agency. The committee substitute was filed at the request of the governor, and it differs from the bill as filed in that it changes the minimum time required for court-ordered chemical dependency treatment from 60 to 30 days. Thank you.
Thank you. Members, any questions? If not, the chair now opens up the floor for invited testimony. I see no one registered for invited testimony. Invited testimony is closed. Now for public testimony, I see the chair calls Christine Bussey. I hope I pronounced that correctly. Good morning. For the record, your name who you represent, your position on the bill, and you have 2 minutes.
Thank you. Good morning, everyone. My name is Christine Bussey. I'm here from NAMI, Texas, the state organization representing individuals and families affected by mental illness. We're here in support of HB 171. Senator Zaffarini's layout was comprehensive, and we're available if there are any questions.
Any questions, members? Thank you very much for being here this morning.
Thank you.
The chair sees no one else registered for public testimony. Anyone wish to testify on, for, or against House Bill 171? If not, public testimony is closed. We'll leave the bill pending. Chair lays out House Bill 908. Recognizes the Senate sponsor, Senator Zaffarini, to explain the bill.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 908 is by Representatives David Spiller, Lalani, Greg Bonin, H.A. Davis, Johanna Harris, Richard Hayes, Mark LaHood, Janie Lopez, Ray Lopez, Will Metcalf, Penny Morales-Shaw, Matt Morgan, Sergio Munoz, Katrina Pearson, and Representative Plessa, Shelby Slauson, and Trey Wharton. It is bipartisan. The bill relates to reporting by law enforcement agencies of missing children to the National Center for Missing and Exploited Children. Members, in 2024, 31,864 children were reported missing to the Texas Center for the Missing, but only 3,068 of them also were reported to the National Center for Missing and Exploited Children. I know you don't need the explanation, so I'll cut to the gist of the bill, which would require the law enforcement agencies also to report missing children to the National Center for Missing and Exploited Children within 2 hours of receiving a report.
Members, any questions? Hearing none, the chair now opens for invited testimony. There's no one registered for invited testimony. Chair closes invited testimony. Chair now open for public testimony. The chair calls Glenda Durham and Brianna Waldock.
Good morning.
Good morning. Good morning. We'll begin from my right. We'll begin with you. Good morning.
Okay,
So your name, who you represent, your position on the bill, and you have 2 minutes.
I'm Glenda Durham. I represent New Lines of Faith Ministry. We're a prayer group where we pray for missing kids every Saturday night. I'm for this bill, and it was created by my representative, David Spiller, and it was taken up by Senator Zaffarini, and I thank you for that. I am here to express my strong support for the proposed legislation regarding the reporting of missing children by law enforcement agencies to the National Center for Missing and Exploited Children. This act is a crucial advancement in our collective responsibility to protect our most vulnerable population, our children. A significant aspect of this legislation is the requirement for law enforcement agencies to enter information regarding a missing child into the appropriate databases within a strict time frame of 2 hours. This amendment is critical because it eliminates the discretion, how they feel, that law enforcement officers might have exercised regarding whether or not a child is truly missing. By establishing a uniform standard, we ensure that every report of a missing child is treated with the urgency and seriousness it deserves, without the risk of delay based on subjective assessment. The dual requirement for immediate investigation and timely reporting, regardless of the circumstances surrounding the disappearance, ensures that actions are taken swiftly. In cases involving missing children, every moment counts, every minute counts. The provisions laid out in this legislation compel law enforcement agencies to act promptly and decisively, thereby enhancing the chances of a successful recovery. Moreover, the order to enter the child's information into both state and national databases, facilities, interagency collaboration on
Thank you for your testimony.
President.
The two minutes are up.
Well, I would like to just close and say that, every child has the right to walk safely on Texas soil.
Thank you very much for being here.
You're welcome.
Your name, who you represent, your position on the bill, you have 2 minutes.
Good morning, Chair Flores and members. My name is Brianna Waldock. I work for Tex Protects. We are in favor of HB 908. This bill keeps kids safe and codifies best practice. I'm happy to answer any questions.
Thank you. Members, any questions? Thank you all for being here.
Thank you.
Thank you both very much.
The chair sees no one else registered publicly to testify. Anyone wish to testify on, for, or against House Bill 908? If not, public testimony is closed. We'll leave the bill pending.
Thank you, Mr. Chairman and members.
Senator King? 1443. Chair lays out House Bill 1443 and recognizes the Senate sponsor, Senator King, to explain the bill.
Thank you, Mr. Chairman, members. I won't go into a great deal of detail on this because it gets pretty hideous, but it deals with these childlike sex dolls that are full size and they're used for grooming people to actually assault children at the end result. Current state law criminalizes the possession with intent to promote obscene devices, which could include childlike sex dolls. However, state law does not currently criminalize possession without intent to promote, leaving a gap for enforcement against these devices. HB 1443 further prohibits possession and promotion of these dolls. The bill makes it a second-degree felony for knowingly possessing these dolls, a third-degree felony for possessing with the intent to promote these dolls, and a state jail felony for possessing the dolls at all. Additionally, the bill establishes that a person who possesses 2 or more dolls is presumed to possess the devices with the intent to promote, resulting in the increased penalty for that person. Lastly, the bill establishes an affirmative defense to prosecution for law enforcement who may possess these devices for law enforcement purposes.
Members, any questions? Senator Hinojosa?
Thank you, Chairman. I guess it's okay to have one sex doll by reading your bill.
No, it's I had to read through the penalty structure 3 or 4 times to get it because it's kind of confusing, but it still remains a felony to just possess one.
Okay, thank you.
But it is really confusing the way they've Ledge Council structured it.
That's what sort of got me to ask the question.
But it'll remain a felony to possess it, and it's enhanced if you're doing it for promotion, and promotion is presumed if you've got more than one in your possession.
Thank you, Senator King.
Thank you.
Senator Campbell?
Just a comment. I think that's disgusting, and I'm glad you have it.
It is disgusting.
It's dirty. It's
Yeah.
sickening.
Yeah.
Thank you.
Amen.
Any questions? Members? If not, the chair now opens up for invited testimony. There's no one registered for invited testimony. Invited testimony is closed. Chair now opens for public testimony. Chair sees no one registered for public testimony. Does anyone wish to testify on, for, or against House Bill 1443? Hearing none, public testimony is closed. We'll leave the bill pending. Chair lays out House Bill 5667, recognizes the Senate sponsor, Senator King, to explain the bill.
Thank you, Mr. Chairman. This bill will change life as we know it. It's right now the judge of the 43rd Judicial District in Parker County is automatically designated as the chairman of the Juvenile Board of Parker County. This just makes it where the board can pick whoever it wants from the board to be the chair, to the great relief of the judge of the 43rd.
Okay. Any questions, members? If not, we'll move on to invited testimony. I see no one registered for invited testimony, so invited testimony is now closed. Chair no one for public testimony. We see no one here for public testimony either. So public testimony is there anyone wish to testify on, for, or against House Bill 5667? If not, public testimony is closed, and we'll leave the bill pending.
Thank you, Mr. Chairman.
Good morning, Senator.
Morning.
Chairman. Chair lays out House Bill 4263. The chair sends up the committee substitute for House Bill 4263. Is there any objection to adopting the committee substitute for House Bill 4263? Hearing none, so ordered. Recognize Senator Perry to explain the bill and the committee substitute.
House Bill 4263 by Representative David Cook is a TJJD workforce retention. HB 4263 allows staff outside the central office to serve on release review panels, giving faculty staff more say in when juveniles are released from a state facility. In addition, it cleans up the staff disciplinary process to better comply with agency grievance policies. The committee substitute removed the language that would have allowed a juvenile corrections officer to receive a one-time annual payment for unused vacation to eliminate the fiscal note.
Members, any questions? Any questions? If not, invited testimony is now open. I see no one registered for invited testimony. Invited testimony is closed. Chair now opens for public testimony. Chair sees no one registered to testify publicly. Is there anyone wishing to testify on, for, or against House Bill 4263? If not, public testimony is closed, and we'll leave the bill pending. We've got another one?
2282. It's another big bill.
They're all important. Chair lays out House Bill 2282 and recognizes its Senate sponsor, Senator Perry, to explain the bill.
Thank you, Mr. Chairman. HB 2282 by Representative Janie Lopez is a arrest warrant fee increase. Currently, a defendant's required to pay $50 for the execution processing of an arrest warrant. Their HB 2282 would simply increase the arrest warrant fee from $50 to $75 because, as we all know, everything costs more these days.
Any questions, Senator Perry? If not, we will now open for invited testimony. There's no one registered for invited testimony. Invited testimony is closed. Chair now opens up for public testimony. I see two witnesses, Larry Gallardo and Rylan Maxsood. Good morning.
Morning.
We'll begin with you, and you state for the record your name, who you represent, your position on the bill, and you have 2 minutes.
Yes, sir. Good morning, Chairman Flores, members of the committee, and my Senator Chuy Hinojosa. Thanks for allowing me to be here. My name is Constable Larry Gallardo, and I'm from Hidalgo County. I've been a constable for over 24 years. I'm here in support of House Bill 2282, representing the Justice of Peace and Council Association of Texas, the large association of the most elected officials in the state. Thank you for the opportunity to speak to you today about this bill. This bill proposes a long overdue increase in the fee for executing processing arrest warrants from $50 to $75. As a working constable, I can tell you firsthand, we've been doing more with less for decades. The current $50 fee, set over 30 years ago, no longer reflects the actual cost of serving a warrant in today's world. Fuel, vehicle maintenance, technology, training, insurance, and all those things that have gone up significantly, but the fee has stayed the same. Most people don't realize that millions of taxpayer dollars are currently subsidizing warrant enforcement across the state. When the defendant doesn't reimburse the true cost of warrant service, the burden falls directly on the taxpayer. HB 2282 helps shift the cost off taxpayers and back to the convicted defendant where it belongs. Our data shows that real cost of serving a warrant ranges from $75 to $104, depending on the distance, time, resources involved. That includes wear and tear on our vehicles, fuel prices, and even the cost of computers and technology needed to track and process warrants safely and accurately. This bill also strikes the right balance by acknowledging the needs of indigent defendants. Court already has discretion under Article 43.09 of the Code of Criminal Procedures to waive or defer fees for those who truly can't pay. So we're not locking people out of justice. We're just making sure that those who can pay do pay their fair share. HB 2282 is about fairness, fiscal responsibility, and the public safety. It ensures that local governments are forced to dip into property tax revenues to fund services that should be reimbursed directly through the justice system. I urge you to support this bill and bring this fee into modern era. Thank you for your time and consideration. I'm happy to answer any questions.
Thank you for your testimony. Thank you for being here.
Thank you. Good morning, Senators. My name is Rylan Maxsood. I'm testifying against HB 2282 on behalf of both myself and the Texas Fair Defense Project. First, I want to acknowledge why this bill may seem like an attractive idea. It raises from $50 to $75 a court cost in any criminal case where a warrant was executed or processed. That sounds a lot like shifting the cost of police time arresting bail jumpers onto the fugitive. But in reality, this bill has little to do with law enforcement and is merely a regressive tax backed by incarceration that goes to county or city general funds to be used for any purpose. Of the millions of arrest warrants issued in our state annually, around 90% come from fine-only offenses in justice and municipal courts. There are two common types of warrants. The first are bench warrants for those who fail to appear on citations because they cannot pay and often fear being placed in jail. The second are capias pro fines, warrants to place someone in jail despite their appearance solely because they fell behind on payments. The vast majority of these warrants are never executed. They're simply placed in the computer to have the court send out scary letters threatening arrest that are eventually removed once the defendant has enough money to pay. No police time is used in these cases, despite being processed by the computer and accruing the fee. Warrant fees make tickets much more expensive only for folks who do not have the money up front. And they prevent case disposal because judges waive only around 2% of fines and fees in Texas, which is optional, ultimately. I don't think $75 per charge, hundreds per person, is the right number to send to general revenue funds for solely computer processing. Those who cannot afford all the fines and fees eventually fulfill them in jail at a rate of $150 a day, costing the county. Court costs are supposed to be reimbursements, not punitive taxes, unlike fines. Please do not raise this discretionary regressive tax backed by incarceration. I'm always available for any questions. Thank you.
Thank you for your testimony. Members, any questions? Thank you all very much for being here this morning.
Thank you. Have a good day.
The chair sees no one else registered for public testimony. Is there anyone who wishes to testify on, for, or against House Bill 2282? If not, public testimony is now closed, and we'll leave the bill pending. Chair lays out House Bill 3464. The chair sends up the committee substitute for House Bill 3464. Is any objection to adopting the committee substitute for House Bill 3464? Hearing none, so ordered. Recognize Senator West to explain the bill and committee substitute.
Thank you very much, Mr. Chairman. House Bill 3464 by Representative Mesa increases the criminal penalties for providing or possessing with intent to provide a controlled substance, dangerous drug, or alcohol to a prison inmate by correctional facility employees. Mr. Chairman, I do have the committee substitute that you sent up. First, the principal difference between the bill as engrossed and the committee substitute is that we've added, at the request of the Department of Criminal Justice, additional language. Unfortunately, all of their language didn't make it into the substitute. It did make it into the substitute, and based on what I was told. The substitute makes it a second-degree felony if a person brings a controlled substance or dangerous drug into the correctional facility. If it's used and the person dies, it makes it a first-degree felony.
Any questions, members? Any questions? If not, the chair. Senator Hagenbu.
Just a real quick question. Is this a very prevalent thing that happens?
In terms of, I can't give you the statistics, but I understand it is a problem. We have resource.
No, that's just a rough idea. It's a good bill. I just was surprised.
You know, unfortunately, people want to make side money.
Yeah.
Things like that.
Okay. Well, thank you for the bill. Appreciate it.
So the chair now opens up for invited testimony. The chair sees no invited testimony registered. The invited testimony is closed. The chair now opens up for public testimony. The chair calls up Michael Santos, Matthew Ferguson, and Charlie Maloof. Good morning.
Good morning. Good morning, sir.
Well, good morning. We'll begin with you, Major, and take your name, who you represent, your position on the bill, and you have 2 minutes.
Good morning. My name is Matthew Ferguson. I'm a peace officer with the Harris County Sheriff's Office. I'm a major in the Detention Command. The Sheriff's Office supports House Bill 3464. The bill supports our efforts over the last 2 years to deter the introduction of narcotics into the jail. On any given day, there are about 10,000 inmates in the Harris County Jail. Drugs inside the jail affect the employees and the prisoners we serve. Similar to jails and correctional facilities around the country, the Harris County Jail has seen an increase in overdoses. The bill enhances penalties for those who introduce the drugs into the jail, often benefiting financially from those who suffer from addiction. I urge you to support the bill.
Thank you.
Good morning, Mr. Chairman, Mr. Vice Chairman, distinguished members of the committee. My name is Charlie Maloff. I'm an honorably retired and decorated public servant and military veteran, and I'm formerly incarcerated. I'm representing myself, and I'm the Vice President of and representing Texas Cure Criminal Justice Advocacy Organization. We are for 3464. This bill increases the penalties for any employee providing controlled substances to a person in custody. The number of overdoses in TDCJ is unacceptable. The current penalty scheme for the penal code is based on weight. You do not have to be a major drug dealer to bring in a controlled substance into a prison to effect an overdose. The street value of any illegal drug brought into a prison is significantly higher as well, making the financial enticement for staff to cross the line acceptable. I addressed this in the Corrections Committee when this bill was heard, and I'm addressing it again here because TDCJ continues the practice if one person gets caught, the whole section of the prison suffers with 15-day lockdowns, borderlining on multiple constitutional violations. Locking down a prison for a riot is one thing. Locking it down because staff is actively engaged in organized crime and the administration cannot control it, so they use the inmates for police the prison is unacceptable. Compounding this problem is punitive action with no due process for those who are innocent is a repeat with many times multiple 15 days lockdowns, causing tensions to rise in unsafe conditions for this section for the inmates and the guards. What makes this worse is how they take the guilty party out of the housing area, then knowingly and intentionally returning them to be subjected to assault, sometimes with life-threatening injuries. This is called deadly conduct under the Texas Penal Code. This alone is illegal and all get out and violates multiple state and federal criminal laws. And when an inmate sustains serious bodily injury because they were thrown to the wolves, every staff member engaged in that process needs to be criminally charged for that aggravated assault under Texas law parties. That practice needs to stop. If all visitations are canceled and these guys have been locked down all this time, where are the drugs coming from? Simply walking off a staff from the unit, maybe terminating or charging them is unacceptable. These staff members have a duty to protect, not a duty to abuse their authority and engage in organized profit hiding under the color of law.
Thank
Please
you for your
pass this bill.
testimony. Thank you for being here.
Thank you.
Thank you. Captain?
Thank you. Board members, senators, thank you. Captain Mike Santos, Harris County Sheriff's Office. I support 3464. To answer your question, sir, it happens quite often. Just had a girl last week, rushed to the hospital. She took fentanyl. It not only makes the jail safer, the people who work there, to me, is more important. They have to come in contact with these drugs that are coming in. And like he just said, they're coming in a variety of ways. People hide them in body cavities. Who knows how they're coming in? But staff is bringing it in. And we need to send a stronger message to them, letting them know if you bring drugs into our jail or any jail and someone gets hurt or worse, someone dies, they're going to face the penalty. So please, I urge you guys to support this bill. Thank you.
Senator Hinojosa.
Thank you, Chairman. Just a quick question. From your testimony, it seems like once you find out that drugs have been smuggled into the prison, you take out the person, the inmate who received those drugs, identify that person, take him out after a lockdown or whatever, or stopping visitation. Then you put back the same inmate back into the prison population, and they have a blanket party where they beat him up.
That's the good word for it, yes, sir. And so once you take the person out and you've identified that person, why not remove them from the prison? Send them to another unit, put them in solitary at a different unit, take it away, and you're taking them away from the source. And so now it's a matter of tracking who the source is, and then you can identify and then go after the source as well. And so when you're bringing something like fentanyl and you have a person dies, well, why did that person die? Who brought it in to begin with? If I'm on the street, I'm going to charge that dealer. Why are these people not charged as well? And so, but it's putting that person back into the system, into the same pod where the problem started. That's where the problem, it really arises, because you're putting the people at jeopardy. You're creating such a tension.
Thank you for answering my question.
Thank you.
Thank you. Any more questions? Thank you all for being here. Appreciate it.
Thank you all for your service.
Thank you.
Chair sees no one else registered for public testimony. Does anyone wish to testify on, for, or against House Bill 3464? Hearing none, public testimony is closed. We'll leave the bill pending. Chair lays out House Bill 285, recognizes Senate sponsor, Senator West, to explain the bill.
Thank you very much, Mr. Chairman and members. This bill is Bardez, Leach, Myers, Moody, Cook, et al. It passed the House by a whopping 125 to 5 vote. The Texas Penal Code on non-livestock animal cruelty states that a person commits an offense if the person intentionally, knowingly, or recklessly kills or causes serious bodily injury to animals by actions such as torture, abandonment, cruel transportation, and more. What this bill does, it adds an additional multiple culpable mental state to this particular crime, criminal negligence. That's what it does.
Any questions, members? If not, the chair opens up now for invited testimony. The chair calls up Maria Mecca. For the record, your name, who you represent, and you may begin your testimony.
My name is Maria Mecca. I represent myself and the hundreds of Texans that I have connected with that have had their dogs killed by pet service businesses. 4 years ago this week, my dog Poncho, a 2-year-old black lab, was killed by a Dallas dog daycare. The business lied to us, said that Poncho ran away on a walk, and sent us on a desperate search to find him. After police were involved, they discovered the business was lying. We collected video surveillance from neighboring homes, uncovering that Poncho had been killed by the business and his body had been dumped in the trash, never to be recovered. My husband and I quickly learned that there's a loophole in the current animal cruelty law that allows Texas pet service businesses to act with impunity by simply claiming negligence. All they have to do is say, "I didn't mean to kill your dog," no matter how egregious their actions have been. We started the Poncho's Promise Foundation, began working with Representative Ordaz and Senator West, and collected hundreds of Texan stories who have experienced similar tragedies. Those written testimonies from those Texans are in front of you now. When you hear and read these stories, I want you to remember that all of these businesses acted with impunity under the current law. In Houston, Texas, Goose, a griffin, Porter, a chocolate lab, and Trooper, a small dog, were all killed on the same day by a Dallas dog daycare, sending 4 other dogs into emergency intensive care. Necropsy reports showed that the dogs had extreme heat exhaustion, multiple lacerations on their body, and rat poisoning found in their systems. In Arlington, Texas, Brooklyn, a Bernese poodle, Hershey, a German shepherd, and Booster, a husky, were all killed in the last 2 years by the same Texas dog trainer who held their bodies for days before notifying owners to hide any evidence of the cause of death. Maverick, a German shepherd, was killed by a trainer who left him running on a treadmill for hours in a hot garage. These stories go on from Texans, and I have heard from Texans in every Senate district in the last 2 years. Whether it's groomers leaving dogs on a table, tethered by the neck, and they slip off and hang during a cigarette break, or doggy daycares, boarders, and trainers leaving dogs in the Texas heat to die, these businesses are currently acting with impunity, and we now have the opportunity to change that with Poncho's Law. Texas dogs and dog families deserve a higher standard of care, and I urge you to support Poncho's Law, HB 285. Thank you.
Thank you, members. Any questions? Thank you very much for your testimony.
Thank you for being here.
Chair sees no more invited testimony. Invited testimony is closed. Chair now opens up for public testimony. The chair calls Paul Mecca and Ashley Morgan. Good morning. We'll start with you and your name, who you represent, your position on the bill. You have 2 minutes.
Good morning. Thank you very much. My name is Ashley Morgan, and I'm a board member of the Texas Humane Legislation Network. I'm also an attorney, and I practice here in Austin. I'm the former chair of the Animal Law Section of the State Bar of Texas and the current chair of the Animal Law Section of the Austin Bar Association. I'm here to testify in strong support of House Bill 285, and I want to thank Senate sponsor West and the bipartisan authors in the House. This bill would add criminal negligence to the animal cruelty statute. You may be asking yourselves, why is a civil trial attorney here instead of a prosecutor? Well, because the civil trial attorneys like myself are the ones that get the calls from these people who are desperate, trying to find some way to get some kind of retribution and justice for their animal. And I, more often than not, have to tell these folks, there's nothing I can do for you, because there's no way to get attorney's fees. There are very few penalties as far as financial recourse for these folks, and so there's really just nothing that I can do for them. And so that's why I'm here to testify in support of this bill. As you probably know, criminal negligence is already defined in the penal code, so this is not a new type of mens rea or subjective intent that we're injecting into this law. Because I'm limited on time, I want to make sure and address some of the public comments that you may have been receiving. I've read the public comments. And some folks have voiced opposition to this on the basis that they're horse owners and they're upset about how this might impact the livestock cruelty statute. That simply is not the case, because this bill only amends Section 42092 of the Penal Code, which is cruelty to non-livestock animals. Cruelty to livestock animals is a separate statute. But more importantly, I want to clearly distinguish that what people are calling the veterinarian exception in subsection D1 is not an exception, it's a defense. And the veterinarian has to prove that they were in the actual discharge of veterinary care when they were doing the activity that is being questioned. And so, you know, you'll hear about the Ashley Watts story, that veterinarian that shocked the horse hundreds of times, and that would still be prosecuted even with this bill. So I urge you to support it.
Thank you for your testimony. Good morning.
Good morning. Thank you to the committee. You know, I can't really say much more.
If you can say your name.
Oh, sorry. My name is Paul
Say your
Mecca.
name, who you represent.
I'm for the
Position
bill.
on the bill, and you got 2 minutes.
And I want to thank Senator West and also Representative Ordaz for getting the bill to this point. Basically, what this bill does is close a loophole, negligence. We hear it far too often. I want to draw attention to one part of the letter from Texas Attorney Randy Turner in the packet that you have, where he says, these pet service businesses have no legal incentive to be careful and not commit negligence. Ultimately, that's the problem. No matter what they do act with impunity because that's the sort of get-out-of-jail-free card for them. So what this would do, as also referenced by Attorney Don Fear in that packet, in his letter, he says, HB 285 provides a basis for pursuing criminal prosecution for negligence, providing Texas families an avenue for justice. By passing this bill, we close that loophole, and we believe that will have a strong effect on these businesses cleaning up their act and taking better care of our pets.
Thank you. Thank you for your testimony. Any questions, members? Thank you all very much for being here.
Thank you all. Appreciate the testimony.
Chair sees no more registered for public testimony. Anyone wish to testify on, for, or against House Bill 285? Not, public testimony is closed, and we'll leave the bill pending.
Mr. Chairman?
Yes.
May I have closing comments on this bill?
Please.
Now, as a state senator, I represent a lot of different people, but also represent a lot of pet owners. And I know that these animals become, frankly, members of the family. And we should do everything possible to protect our family members. And this bill is another step in terms of making certain that protection is there.
Thank you, Senator.
Thanks, Senator West.
Not, leave the bill pending. Chair lays out House Bill 2355 and recognizes Senate sponsor Vice Chairman Parker to explain the bill.
Thank you, Mr. Chairman, members, for the opportunity to come before you and lay out House Bill 2355. Right now, the Crime Victims Compensation Program helps victims and their families cover immediate costs following a crime. This program is administered today by the Attorney General's office. The program can cover a range of expenses, including medical bills, lost wages, and even counseling services. To determine the compensation amount, the Attorney General's office has special access to key documents such as law enforcement reports, witness statements, and criminal history records. These reports are still considered privileged based upon the original law enforcement agency, whom the AG pulls the records from, and are generally withheld from the public. However, once the Attorney General pulls the records, they can become subject to the requirements under the Public Information Act for the Attorney General's office, which may not always be applied the same as the originating law enforcement agency because the Office of the Attorney General is not an investigating agency in this instance. And so this bill, Mr. Chairman and members, is very straightforward. It closes that loophole to ensure not only victims are better protected, but details surrounding ongoing investigations are in fact kept confidential. And so appreciate the chance to lay out the bill here this morning.
Members, any questions? If not, we'll open up for invited testimony. There's no one registered for invited testimony, so invited testimony is closed. Chair now opens for public testimony. Chair sees no one registered for public testimony. Anyone wish to testify on, for, or against House Bill 2355? Chair hearing none, public testimony is closed, and we'll leave the bill pending.
Thank you, Mr. Chairman.
Did you want, are you going to lay down?
2637?
Yes.
Yeah, for Brian.
Chair lays out House Bill 2637, recognizing Senate sponsor, Senator Parker, on behalf of Senator Hughes, to explain the bill.
Thank you, Mr. Chairman. Members, appreciate the opportunity to come before you here this morning with HB 2637. In 2023, HB 3474 raised the juror exemption age for pettit injuries to 75, yet the exemption age for grand jurors remained at 70. This discrepancy has created inefficiencies in jury wheel management. The changes in this bill are also in Senate Bill 2878. HB 2637 increases judicial efficiency by allowing clerks to prepare separate reports on jury exemptions and disqualifications. Currently, these reports are combined, and HB 2637 will ensure that voter registrars are not sent unnecessary information. HB 2637 raises the grand jury exemption age to 75 years and older. Standardizing the exemption age will increase the pool of eligible jurors and allow district clerks to better manage the jury wheel for both pettit and grand juries. The bill also clarifies that being convicted of a misdemeanor, theft, or a felony conviction disqualifies an individual from serving on a jury. HB 2637 ensures that all clerks are required to permanently remove these individuals from the juror wheel. And lastly, the Secretary of State requires a report on individuals with misdemeanor, theft, or felony convictions in order to remove them from the jury wheel. For voter registration purposes, only felony convictions impact voter eligibility. Currently, clerks cannot distinguish which type of disqualification an individual claims. And HB 2637 separates the two convictions on the disqualification list so clerks can move more accurately to report the necessary information to the Secretary of State and voter registrar. So
at this point, I'll send up committee substitute for House Bill 2637. Is there any objection? Senator Parker will explain the committee substitute.
Thank you, Mr. Chairman. The committee substitute makes minor clarifying changes to ensure voter registrars only get jury exemption information that impacts voter registration status. This language makes it clear that when the district clerks are sending the lists of disqualified persons from grand jury service, voter registrars receive information about individuals disqualified due to felony conviction and citizenship, and it removes the 75-plus age exemption report from being sent to the voter registrar, along with felony indictments, misdemeanor theft indictments, or convictions, all of which are unnecessary for voter registration status. Clerks will continue to send this information to the Secretary of State and prosecuting attorneys. And so thank you, Mr. Chairman, for allowing me to lay out the bill and the substitute on behalf of the Senate sponsor, our colleague, Senator Hughes.
Senator Hinojosa.
Thank you, Mr. Chairman. You may not know the answer, I don't know, but we're not taking away the discretion from a judge to be able to excuse a juror for whatever reason.
Senator, I'm just obviously looking at the bill here this morning, but no, it doesn't look like it to me that we are taking that away. That is correct.
Okay. I'll try to read pretty fast, but pretty long bill.
We can certainly visit with the sponsor, Senator Hughes, further as well, but it doesn't look like it to me in my initial read.
And I'll visit with him on the Senate floor.
Yeah, very good. Thank you, Senator.
The chair now opens up for invited testimony. The chair sees no invited testimony. Invited testimony is closed. Chair now opens for public testimony. Chair calls Patty Henry. Patty Henry. Good morning. Just
Good
for the
morning.
record, name, who you represent?
My name is Patty Henry. I'm the Chambers County District Clerk, and I'm here representing the County District Clerks Association of Texas. I want to thank Vice Chair Parker for laying out that bill in such detail. You did my job for me. I'm here for questions, and Senator Hinojosa, I'm happy to answer any questions you might have, or anyone else.
Any questions? Any questions?
Well, I'll just say I appreciate you being here. Thanks for your willingness to testify. I don't know if you want to comment on the question that Senator Hinojosa asked earlier. If you have any insight on that, your perspective on the bill, that would be beneficial for him, and I think for the committee as a whole.
Yes, this bill takes no authority from a judge. This is simply clarifying disqualifications versus exemptions versus the age change between pettit and grand jury for consistency across the courts and the state.
And actually, my main concern was just that we were not taking away the discretion of a judge to be able to excuse a juror for whatever reason. But that many times it happens, that we're not covered by statute, but as a judge questions the juror, the judge on his own may decide, including both attorneys on both sides.
And absolutely, and that typically is not a goal for the clerks to change policy, only to clean up procedures, which is what this bill does. But thank you for bringing that up.
Thank you very much for the excellent explanation and clarifying. So appreciate you being here. Thank you very much.
Thank you for being here. So the chair sees no one else registered. So is there anyone who wishes to testify on, for, or against House Bill 2637? Not public testimony is closed. We'll leave the bill pending.
Thank you, Mr. Chairman.
Thank you. So Senator Cook. Chair lays out House Bill 305 and recognizes Senate sponsor Senator Cook to explain the bill.
Thank you, Mr. Chairman. Good morning, y'all. Good to start your day with you. Thank you for the opportunity to lay out House Bill 305 by Representative Hayes, which passed the House 136-4. When a criminal defendant is deemed incompetent to stand trial, the court orders the defendant to be committed to a state hospital or qualifying facility for competency restoration. In December of 2023, over 2,250 individuals were on the wait list for a treatment bed, which is a 247% increase in just 5 years. A key contributor to this waitlist backlog is the cycle of decompensation that occurs when defendants who have been restored to competency are returned to jail, but court backlogs or unprioritized dockets cause unnecessary delays. According to this Texas State Auditor's 2024 report, 341 individuals appeared on the wait list multiple times for the same charges between 2018 and 2023, which forces the state to pay costly competency restoration multiple times for the same case. Article 46B.084 of the Code of Criminal Procedure establishes procedures for returning restored defendants to courts, but lacks any specific timeline requirements for conducting those pretrial hearings. This statutory vacuum allows indefinite delays between restoration and court proceedings. Texas law already recognizes the critical window following competency restoration because we require a 30-day supply of medication for folks, but without a corresponding requirement for timely court proceedings, the med provision alone is insufficient to maintain competency. So HB 305 requires that a court conduct the next pretrial hearing for a defendant who's been restored to competency within 14 days of the defendant's restoration. It will prevent unnecessary decompensation of defendants while awaiting trial, reduce strain on the forensic wait list, conserve law enforcement resources, and promote efficiency and public safety. And it answers the call of so many sheriffs around the state who say that this will really help with the wait list revolving door. With that, I'm happy to answer any questions.
Members, any questions? With no questions, the invited testimony is now open. I see no one registered for invited testimony. Invited testimony now closed. Chair now opens for public testimony. Chair calls Lizette Galvan. Lizette Galvan. Good morning.
Good morning.
You state your name, who you represent, your position on the bill, and you have 2 minutes.
All right. Good morning, Chair Flores and members of the committee. My name is Lisette Galvan, and I serve as the Public Policy Director for NAMI, Texas. I'm testifying in support of HB 305, which aims to reduce the time individuals with mental illness spend in county jails after competency restoration. Texas continues to struggle with a growing forensic waitlist crisis, leaving individuals with mental illness stuck in jails while waiting for competency restoration. As Senator Cook laid out, according to the Texas State Auditor's report from November 2024, approximately 341 individuals were found competent and returned to county jails to later decompensate and were found incompetent again, restarting the entire cycle. As a result, the 341 individuals were placed on the wait list multiple times, ranging from 2 to 6 times for the same charges. This is unacceptable and highlights the urgent need for reform. HB 305 offers a practical solution by requiring a pretrial hearing to be set within 14 days of an individual's return from the state hospital to county jail. This change is critical to preventing individuals from undergoing prolonged stays in jail and decompensate, which can erase any progress made and further delay justice. By ensuring a timely pretrial hearing, HB 305 helps reduce the likelihood of individuals cycling back into incompetency, alleviates strain on our overcrowded state hospitals and county jails, and upholds the dignity and the rights of those with mental illness. I urge you to support HB 305 to ensure Texans with mental illness receive the care and timely justice they deserve. Thank you for your time and consideration. I'm happy to answer any questions.
Any questions, members? Thank you for your testimony.
Thank you.
Chair sees no one else registered for public testimony. Anyone wish to testify on, for, or against House Bill 305? Hearing none, public testimony is closed. We'll leave the bill pending. Chair lays out House Bill 1741 and recognizes Senate sponsor Senator Cook to explain the bill.
Thank you, Mr. Chairman, for the opportunity to lay out HB 1741 by Representative Johnson, which passed the House unanimously. Under current law, courts may order supervised outpatient or community-based treatment for individuals acquitted under an NGRI, not guilty by reason of insanity verdict. The Code of Criminal Procedure allows this treatment to occur in different counties if the necessary resources are available. However, the statute lacks clear procedures for out-of-state, out-of-county commitments, raising substantial public safety concerns, including a lack of local probation authority. Since jurisdiction remains within the originating court, local probation offices lack the authority to provide supervision. Facility coordination gaps. Receiving facility administrators may not have been involved in treatment planning or properly notified of the commitment. Think no handoff. And then bench warrant execution delay. If the individual fails to comply and must be recommitted to a state hospital, law enforcement faces procedural gaps in executing a capious order, sometimes leading to delays of up to 1 year. HB 1741 strengthens public safety by ensuring that individuals committed under NGRI verdicts receive appropriate supervision and resources while mitigating risks associated with procedural gaps. For an individual to be transferred to another county, HB 1741 ensures the necessary resources are available, the acquitted person has a significant nexus to the proposed county of commitment, some sort of family or social support, and the person can actually be adequately supervised while maintaining the public safety of the community. Once these requirements are met, if the receiving county accepts jurisdiction, the committing court will transfer the case to the new court to ensure the rights of the local authorities to supervise the individual. We have one invited testimony, and I'm also happy to answer questions. And we have someone from the Forensic Mental Health Harris Center here as a resource as well.
Members, any questions? Not, the chair now opens up for invited testimony. Chair calls Aaron Brown. Aaron Brown. Good morning. For the record, your name, who you represent, and you begin your testimony.
Good morning. I'm Sergeant Aaron Brown with the Harris County Sheriff's Office Crisis Intervention Response Team. I'm so excited to be here. I was talking to a colleague earlier. I'm usually the one talking to people in crisis, and I'm literally the person in crisis today. So I apologize. I'm very good at my job, just not at this.
That's okay.
So, thank you for the opportunity to speak today. I'm here in support of House Bill 1741, which addresses a serious public safety concern involving individuals found not guilty by reason of insanity. These crimes are typically very serious, aggravated assault or even murder. These individuals can be released into the community under a court-ordered outpatient treatment. But in practice, we've seen individuals with no connection to Harris County. As many of you know, Harris County is the hub for mental health services. We end up with a lot of individuals that have no ties, no family, no anything. This creates, they're transferred into new jurisdictions, creating serious safety challenges for local law enforcement. If they become non-compliant with their treatment, deputies may have no authority to detain them or return them to a state hospital because of jurisdictional limitations. What's happening is they're not abiding by their outpatient. We have no enforcement on the law enforcement side, and then they reoffend. They commit another serious incident. Texas peace officers, I think for the whole state, nothing's more frustrating than us wanting to prevent violence and that violence happening. House Bill 1741 is a critical step towards closing these dangerous gaps. It will support treatment while giving law enforcement the authority needed to protect communities. I urge your support. I thank each one of you for your time, your commitment to Texans, and I'm happy to answer any questions.
Oh, we thank you for your service. Show Senator Miles is present. Any questions? Any questions? Thank you for being here.
I appreciate you guys.
Thank you for your
so much.
testimony.
Yes, sir.
The chair sees no one registered for invited testimony. Invited testimony is closed. Chair now opens up for public testimony. Chair calls Kristen Holmes. Kristen Holmes. Good morning.
Good morning.
For the record, your name, who you represent, your position on the bill, and you have 2 minutes.
Yes, sir. Good morning. My name is Dr. Kristen Holmes, Program Director for the Harris Center for Mental Health and Restoration in the Jail-Based Competency Restoration Program, and we are on the bill. The revisions contained in Bill 1741 are really about one key issue, ensuring the successful and safe reintegration of a person into the community. As a licensed professional counselor, I know the importance of a solid discharge plan and how providing multiple layers of support and services can set an individual up for failure or success. Individuals who are found to be NGRI are among some of the most mentally fragile within our population. They're an incredibly challenging group of individuals who oftentimes have very limited support systems and struggle with the most basic of needs. For those who spend an extended period of time at state hospital, having the maximum amount of supports available upon discharge is crucial to their success. They not only need support from family and friends, but from the local mental health authority and community judicial and legal supports. One of the first lessons we learn as counselors is that the best predictor of therapeutic success is the strength of the relationship. This is about building a relationship between an individual and their community. In my clinical experience, what I've learned to be true is that individuals have the best chance of success when reunited with family, friends, and circles of support, a local nexus. They want to be with loved ones in familiar places where they can try to restart their life while being fully engaged in their treatment plan. This is why I believe our local NGRI population in Harris County has a 70% success rate, because we engage our population closest to home. They receive the highest level of mental health outpatient services. They're provided with support from the bench in the form of a specialty court docket and close community supervision. But most of all, these services work directly to engage the individual's family and friends to ensure their support at home. Today, I ask these NGRI individuals be afforded the same opportunities. Revisions such as ensuring an individual has a nexus of support is crucial to the reintegration process. Our out-of-county individuals have a 100% recidivism rate, making this a public safety issue.
Thank you very much for your testimony. Is there any questions, members? Thank you for being here.
Thank you.
Chair sees no one else registered for public testimony. Anyone wish to testify on, for, or against House Bill 1741? If not, public testimony is closed and we'll leave the bill pending.
Thank you, Mr. Chairman. Thank you, members.
Ready? Chair lays out House Bill 2492 and recognizes its Senate sponsor, Senator Hinojosa, to explain the bill.
Thank you, Mr. Chairman and members. House Bill 2492 is a bill being authored by Representative Rada Bowers. Right now, law enforcement can choose to hold someone arrested for family violence for up to 4 hours after bond if there's a probable cause to believe the violence may continue upon immediate release. This is also known as the cooling off period, which gives time for tensions to de-escalate, for the victim to reach safety, or for protective measures to put in place. But because it is discretionary, practices vary and victims may be at risk during this critical and often most dangerous time period after release of the offender. House Bill 2492 would require, rather than allow, law enforcement to hold a person arrested for family violence for 4 hours after they post bond if there is probable cause to believe that violence would continue if the person is released right away. The bill also preserves existing provisions that allow a magistrate to extend the detention period up to 48 hours, additional 48 hours under certain conditions, such as repeat family violence arrest or use of a deadly weapon. And that's what the bill does.
Thank you. Members, any questions? If not, the chair will now open for invited testimony. Chair sees no one registered for invited testimony. Invited testimony is closed. Chair now opens for public testimony, and the chair calls Mark Russo. Mark Russo, good morning.
Good morning.
And for the record, your name, who you represent, position on the bill, and you have 2 minutes. And thank you for being here, Judge.
Thank you. Good morning, Chair Flores, esteemed members. My name is Judge Mark Russo. I'm a Justice of the Peace, representing the Justice of the Peace Constable Association, and I am the judge advocate, and we are in support of 2492. We just think that it just goes from may to a shall and ensures public safety and the safety of the victim to make sure that there is enough advance notice so the victims can adjust accordingly. Thank you for your time today.
Any questions? Any questions? Thank you very much for your testimony.
Right to the point.
Yeah, we like that kind. It's good. If not, the chair sees no one else registered for public testimony. Anyone wish to testify on, for, or against House Bill 2492? If not, public testimony is closed, and we'll leave the bill pending. You're going to lay out Senator Campbell? Chair lays out House Bill 1445 and recognizes the Senate sponsor, Senator Hinojosa, on behalf of Senator Campbell, to explain the bill.
Thank you, Mr. Chairman. Thank you, Mr. Chairman and members. House Bill 1445 relates to the compensation of counsel appointed to provide representation and services to indigent individuals in criminal and juvenile proceedings. And Representative Ana Hernandez and Mike Schofield are the House authors. Certain counties assign attorneys for those who cannot afford a lawyer in criminal cases called Managed Assigned Counsel programs. This is House Bill 1445, the identical companion bill to Senate Bill 2009, which passed unanimously out of this committee and will simply allow the Managed Assigned Counsel director the option to establish a designee they would assign in approving this type of payments to attorneys if necessary.
Any questions? Any questions? If not, the chair now opens up for invited testimony. Sees no one registered for invited testimony, so now invited testimony is closed. Chair now opens it for public testimony. I see no one registered for public testimony. Is there anyone wish to testify on, for, or against House Bill 1445? If not, hearing none, public testimony is closed, and we'll leave the bill pending. Senator Hagenby? Chair lays out House Bill 1024 and recognizes its Senate sponsor, Senator Hagenbu, to explain the bill.
Thank you, Mr. Chairman. Members, appreciate the opportunity to lay out House Bill 1024 by Representative Matt Shaheen. In July 2018, Jose Rodriguez, a state prison parolee ordered to wear a GPS ankle monitor, removed his device and went on a week-long crime spree in Houston, murdering 3 individuals and robbing 2 others. Despite having an outstanding arrest warrant for violating parole, authorities took 3 days to issue the warrants, allowing these preventable crimes to occur. House Bill 1024 instructs law enforcement to execute as soon as practicable a warrant for the return of an individual who violates the conditions of their parole and is being monitored under the Superintensive Supervision Program, also referred to as SISP. This tier of parole supervision is for the most heinous acts, such as a murder, kidnapping, and indecency with a child. A problem exists, however, when a warrant is issued for a parole violator, but law enforcement is delayed in their response, which could place the victim or general public at risk. Appreciate your consideration of this bill.
Thank you. Any questions? If not, the chair now opens up for invited testimony. I see no one registered for invited testimony. Invited testimony is closed. Chair now opens up for public testimony. The chair sees no one registered for public testimony. Is there anyone here wishing to testify on, for, or against House Bill 1024? Hearing none, public testimony is closed, and we will leave the bill pending.
I have 1306 for...
You're going to do it for Senator Sparks?
Yes.
1306, Senator?
Yes.
The chair lays out House Bill 1306 and recognizes its Senate sponsor, Senator Hagenbu, on behalf of Senator Sparks to explain the bill.
Thank you for the compliments, Mr. Chairman. Thank you for the opportunity to lay out House Bill 1306. It entitles Death Investigation Professionals, including medical examiners, justice of the peace, and death investigators, many of the same benefits as first responders. These include reimbursement for medical expenses related to exposure to contagious disease, access to preventive immunization, expedited medical benefits for work-related injuries, and line-of-duty death benefits for families. Medical examiners and death investigators frequently respond to the same scenes as law enforcement and EMS and face many of the same risks, including disease exposure and handling of human remains. Making sure they have this support will not only help them do their job safely and effectively, but will also make it easier to recruit and retain qualified personnel in this field. Thank you for your consideration of this bill, Mr. Chairman, members.
Thank you. Is there any questions? Senator Hinojosa, you have your light on, or you have a question? If not, no questions. Chair now opens up for invited testimony. I see no one registered for invited testimony. Invited testimony is closed. Chair now opens up for public testimony. Chair sees no one registered to testify publicly. Is there anyone here wishing to testify on, for, or against House Bill 1306? Hearing none, public testimony is closed, and we'll leave the bill pending. Okay, which ones? Oh. Okay, so we'll start with 449. Chair lays out House Bill 449. The chair sends up the committee substitute for House Bill 449. Is there any objection for adoption of the committee substitute for House Bill 449? Hearing none, so ordered. I recognize Senator Hinojosa on behalf of Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. In 2023, Chair Huffman was proud to author Senate Bill 1361, making it a criminal offense to knowingly produce or distribute a deepfake video without the effective consent of the depicted individual that appears to show them with intimate parts exposed or engaged in sexual conduct. However, this bill did not criminalize sexually explicit photos that are created of people without their consent. House Bill 449 would include deepfake sexually explicit photographs as illegal under the current statute. And as technology involves too much of our statutes are behind in trying to keep the forms of damaging material that are included. The committee substitute adopts a broader definition of deepfake video. This is the same definition that was used by myself when I introduced Senate Bill 442, which passed the Senate and is currently moving through the House. I'll be glad to answer any questions.
Any questions, members? If not, the chair now opens up for invited testimony. I see no one registered for invited testimony, so invited testimony is closed. The chair now opens up for public testimony. I see the chair recognizes Adrian Shelley. Adrian Shelley. Good morning. For the record, your name, who you represent, your position on the bill, and you have 2 minutes.
Good morning, Mr. Chairman, members. Adrian Shelley, I'm the Texas Director of Public Citizen, speaking in support of the bill. As explained in the layout, this bill simply adds images to the existing criminal statute, which criminalizes unlawful production or distribution of sexually explicit deepfakes. That is a Class A misdemeanor under the current law. This is a problem that has exploded in recent years. There was a tenfold increase in circulation of deepfakes on the internet from 2022 to 2023. In 2023, there were over 95,000 deepfake videos that were circulating online. The victims of this content are 99% women. Majority of them are children. And of the deepfake images that are circulated on the internet, 98% of those are intimate deepfakes. So this is a problem among women and children. It's a problem in our schools as well. There was a study that was conducted by the Center for Democracy and Technology that found that 15% of students in our schools are aware of one of these images being circulated in their school. There was another study by the Institute of Electrical and Electronics Engineers 4 years ago found that 75% of people cannot distinguish one of these deep fakes from a genuine artifact. So this is an increasingly serious problem, and we appreciate the bill for that reason. Thank you.
Thank you. Any questions? Thank you very much for your testimony.
Thank you.
Chair sees no one else registered for public testimony. Is there anyone else who wishes to testify on, for, or against House Bill 449? Hearing none, public testimony is closed and we'll leave the bill pending. (1902). Do you have that? Chair lays out House Bill 1902 and recognizes Senate sponsor, Senator Hinojosa, on behalf of Senator Huffman, to explain the bill.
Thank you, Mr. Chairman and members. According to the Texas Department of Banking, jugging is a crime that involves stealing money from a person who has just withdrawn cash from an ATM or bank by following the victim to a new location and robbing them. Rather than a crime of opportunity like burglary of a vehicle or robbery, jugging is a form of organized crime with sophisticated surveillance tactics and resources. House Bill 1902 creates a criminal offense of jugging, punishable as a state jail felony, which is defined as knowingly traveling from a commercial business or financial institution on the same path or route as another person without substantially deviating from their path or route and possessing two or more criminal instruments. This bill includes a penalty enhancement if the offender commits burglary of a vehicle or robbery in the commission of the offense.
Any questions, members? If not, the chair will now open up for invited testimony. The chair sees no invited testimony. Invited testimony is closed. The chair now opens up for public testimony. The chair calls Celeste Embry. Celeste Embry. Good morning. And for the record, name, who you represent, your position on the bill. You have 2 minutes.
Good morning. My name is Celeste Embry, General Counsel of the Texas Bankers Association, testifying in support of House Bill 1902.
Could you put the microphone closer? Thank you.
Just to frame up very briefly for committee members, this is a growing problem. One of our large member institutions reported over a 3-year period of the 1,700 reported jugging incidents that they were aware of, 65% of those instances occurred in the state of Texas. So we thank Chairman Huffman and Representative Cook. I'm happy to answer any questions, but we are in support of the bill.
Thank you. Thank you for your testimony. Any questions, members? Thank you for being here. So the chair sees no more persons registered for public testimony. Is there anyone wishing to testify on, for, or against House Bill 1902? Hearing none, public testimony is closed. We'll leave the bill pending. 2697. Chair lays out House Bill 2697 and recognizes Senator Hinojosa on behalf of Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. Under the current law, when a bail bondsman relinquishes responsibility for a defendant's bond as a result of a violation of the court-ordered bail bond conditions, the bondsman is under no obligation to notify the prosecuting attorney that the defendant's bond has been canceled. This lack of notification allows a defendant who have violated their bail conditions to abscond the court for months despite the bail bondsman recommendation to order the defendant back into custody. House Bill 2697 requires a surety in cases classified as a felony to notify the prosecution of their intent to surrender a defendant to the court before filing an affidavit effectively canceling their bond. This bill will ensure that defendants who have violated their bail conditions are brought back into custody and protect local communities from those that do not comply with conditions of the release.
Members, any questions? If not, the chair will open up for invited testimony. The chair sees no one registered for invited testimony. Invited testimony is closed. Chair now opens up for public testimony. The chair calls Jason Hermes. Jason Hermes, I hope I pronounced that correctly, sir.
Yes, sir.
And for the record, your name, who you represent, your position on the bill, and you have 2 minutes.
Thank you, Chairman. Thank you, Senators. My name is Jason Hermes. I'm here on behalf of the Dallas County Criminal District Attorney's Office and the DA, John Creuzot, in support of House Bill 2697. I thank you for your time. I know you're busy. I'm available if you have any questions or concerns about the bill.
Any questions, members? Thank you. Thank you for taking time to be here. Chair sees no one else registered for public testimony. Is there anyone here wish to testify on, for, or against House Bill 2697? Hearing none, public testimony is closed, and we'll leave the bill pending. That's all we're talking about? Okay, so we have, what do we have left? Good. Okay. Senator Bettencourt? Chair lays out House Bill 2001 and recognizes the Senate sponsor, Senator Bettencourt, to explain the bill.
Thank you, Mr. Chairman and members. There's an increasing number of bid rigging scandals in the state of Texas. This is a real problem because the public is appalled by bid rigging and by these constant stream of stories where double-digit or multi-million-dollar projects are basically rigged to go to one specific vendor over the other. We've had serious questions about this, and it's important that we set some punishment levels that deter this, as well as make it, an example out of actually taking the public's money and not only just misusing it, but literally providing financial gain to others that should not be able to get a bid awarded, much less the corruption that just permeates this and the public's total distaste for it. There's one case that recently the Harris County Public Health Director, Barbie Robinson, was accused of sharing private information and fraudulently aiding companies such as IBM and DEMA Management Consulting into securing approximately $40 million in its contracts. All 4 counts of felony charges were unfortunately dismissed due to insufficient evidence. However, I believe that the lack of a simple but severe penalty for this behavior probably fed into the situation that I just described. So House Bill 2001 by Representative Chairman Myers, Anchia King, and many others sets the misuse for public information for financial gain is a felony of the 3rd degree, no matter what the monetary amount is. Examples of misuse of official information, insider trading, leaking confidential information, personal financial gain. House Bill 2001 keeps this baseline penalty, but also increases the punishment to 2nd and 1st degree felonies for a public servant with financially gains up $150,000. It's a 3rd degree felony. $150,000 to $300,000 is a 2nd degree felony, and there's actually a 1st degree felony as well, which is higher than that. To basically put it, we just simply have to crack down on any concept that the public sits back and watches that there is corruption on bids in the state of Texas. Additionally, House Bill 2001 increases the penalty for public servants that coerce another into suppressing or failing to report instances of misuse of public information from a Class C misdemeanor to the same tiered felony charges. And Mr. Chairman, I believe I've got Brian Middleton, District Attorney for Fort Bend, Brent Ligon, the District Attorney for Montgomery County, and Texas Rangers Major Wolf here to answer any questions.
Any questions? Senator Hagenbu.
Thank you. Thank you, Mr. Chairman. Senator, this question for you. So obviously you're doing this bill because it's a problem that exists, and this is great. I mean, it's to help deter it. But is there any investigation or procedures we need to do to try to figure out, systematically what's allowing this from a management perspective?
And that is the question. And I would love to have the DAs and the Texas Rangers answer it, because they've been active in trying to get these prosecutions made and also investigated. And obviously they're having difficulty, which is why the law is basically blasted out of the House over to the Senate with a huge bipartisan majority. So that's up to the chairman to call the witnesses.
That'd be good if you don't mind. Yeah, appreciate it.
Chair now calls up opens up for invited testimony. The chair calls Brian Middleton, Jeff Wolf, and Brent Ligon.
Oh, I didn't see Brian back there. He was hiding. Brian Morning. Okay.
Good morning. Good morning. We'll begin, and just for the record,
good morning, sir.
Name and who you represent, and you may begin.
You want to start with?
Yep, right, Mr. Ligon, you can go first.
Good morning. My name is Brent Ligon, and I am the District Attorney of Montgomery County. I have been for the last 17 years, and I am testifying in favor of House Bill 2001.
Good morning. My name is Jeff Wolf. I'm a captain with the Texas Rangers. I've been in law enforcement for approximately 23 years, and I've been in the Texas Rangers for 14. I'm here as a resource expert for any questions y'all might have.
I am Brian Middleton, Fort Bend County District Attorney. I'm here to testify in favor of the bill.
Is there any statement any of you wish to make, or Mr.
I would like to follow up on Senator Hagenbu's question. Part of it deals with the investigation. Yes, sir. Sorry about that. Senator, can you hear me now? I'd like to follow up on Senator Hagenbu's question, specifically in regards to management. What is the reasons why this is occurring? Part of it has to deal with the nature of white-collar crime as opposed to the impulsivity that you deal with violent crime. And so violent crime oftentimes deals with intoxication and a gun and a weapon. And because of that, leaves many clues and trails. And so they're investigated early and often. The problem with white-collar crime is it misses all those elements. Usually people that are committing these crimes are doing them intentionally. And oftentimes they're very clever and they're well thought out. And so the same types of things we'd look for on a scene investigation for a violent crime, those clues aren't there. The second issue that we're dealing with is a very, very limited statute of limitations. Because white-collar crime by themselves are difficult, most people with a prosecutorial background, most people with an investigative background come so from a patrol function, then a supervisory function. We don't come as accountants to the world of criminal law. We come as prosecutors and we come as patrol officers from an investigation standpoint. And so you're dealing with the type of crime that is difficult to detect with a very short statute of limitations. And so oftentimes you have officials. Let's take your common commissioner's court. A commissioner's court, the terms of 4 years. Up until this law, Senator Betancourt's 2001 House bill would change the statute of limitations on several of these offenses, specifically the coercion dealing with Class C. A Class C is nothing more than a 2-year statute of limitations. As the bill is now currently written, it would change those to the felony ranges. And so felony ranges are dealing with a 5-year statute of limitations. Now think about the cleverness involved now. You have a 4-year term. If an official loses after the 4 years, you have a 5-year statute of limitations to investigate these felonies, right? It'd be the next person in who comes and asks for an audit. And so oftentimes what you'll have is that people are in office for long periods of time and there's no new fresh set of eyes. Eliminating this Class C, starting the punishment range as a felony range, also by its very nature, changes the statute of limitations to a period of time that gives us the ability to not only look at the crime itself, but to look backwards. I believe that is one of the concerns, one of the problems that happened with the AG's investigation in regards to who was coercing the individuals below them to keep the bid rigging secret. And what this law secondly does is it prevents insider dealing, but it also seeks to stop outside solicitation. And so you have a very sophisticated business model who now starts to get a government-paid official that perhaps with a high school education and a construction background. So you're dealing with a white-collar business who now starts asking these people who now have control of millions of dollars that have never had those before and start asking, hey, can you tell me about this bid? Can you tell me what it takes for me to be number one? By the way, hey, would you like to go out on my deer lease? You want to go fishing with me? And so this would stop or at least would directly influence the outside solicitation as well as the insider peddling.
Any other comments?
Yes, if I may.
You're welcome.
It's been my experience is that this statute is violated every day, federal, state, and local level. The challenge we have is establishing proof, developing probable cause. There's huge financial gains to be gained by violating these statutes, and these people have a profit motive to protect that status. In law enforcement, our ultimate goal is voluntary compliance, and I think this statute, as is amended, goes a long way to assure that. People who now understand that they will be facing possibly a first-degree felony, and it's my experience that usually these offenses involve million-dollar contracts and bidding processes, so these people will now be confronted with the possibility of a first-degree felony. And I think that goes a long way in obtaining voluntary compliance because it will be a disincentive for these persons to engage in that conduct.
Very well.
Senator Hagan? Yes, please. Thank you, Mr. Chair. I was during my naval career, Civil Engineer Corps. At one point, I had a tour of duty where I was the officer in charge of construction for a Navy base. So over federal acquisition regulations, put out bids and awarded contracts, and can't imagine providing information to a bidder, who's a low bid and all those kinds of things. That's just completely unethical. But I understand it happens, and it's amazing. It sounds like it happens fairly regularly. So this is a great bill. I'm just wondering, and maybe this is for Senator Bencourt as well, beyond this to try to help, stop it or reduce it to a great degree. You mentioned that we don't have white collar people. Don't come up from most of them come up through other kinds of crimes. Is there any recommendations you make beyond this that we could look at there in the interim or something where we would have, if it's significant enough, that we would have a unit or something that's with accountants and things that would look into this kind of thing?
Well, two things. One is, if this bill is passed, the first thing I would do is ask our Commissioners Court to attach this warning on behalf of any contract or any bid. Number one, you've got to tell the businesses out there, whether in construction or medical sales or whether it's environmental, anything COVID-related, all those types of deals where the counties just got flooded with government money and had to start buying things that they had typically never bought before. It was tents, masks, everything. So the first thing I'd ask our Commissioners Court and our County Attorney's Office is to attach this bill or a warning, hey, violation of this, solicitation of this type of information may result in prosecution of up to life sentence. That's the first thing. Second thing you're asking is there a unit or would there be a unit practical on the state side to investigate these type of crimes? And I think I would speak on behalf of Brian and every DA in the state of Texas. Hey, more investigative efforts that y'all flood to the counties are going to be utilized.
All right.
And I would add, Senator, that, sitting next to one of the Texas Rangers, we do have public integrity unit with the Texas Rangers. One of my public integrity investigators is sitting in the back of the room. We work collaboratively, and we also work collaboratively with the FBI. So I think there are resources there, probably need more resources because, as I hinted to earlier, this is often suspected. So we often investigate these allegations and do not come up with the evidence needed to prosecute it. But I would add this one suggestion. In reading the proposal amendment, I think there should be a definition of net pecuniary gain, because I think that's going to be litigated, is how do you calculate that? What math do you use to define that? Which is what we're going to have to develop in the court of law. So if you could add a definition for that, maybe generally accepted accounting principles. It's also defined under the sentencing commentary to the sentencing guidelines. If you look there, there's a definition there. But I think it would help us if we were able to define that so we don't have to litigate that in the courts.
Senator Miles.
Thank you, Mr. Chairman. Senator Betancourt, I think it's a great bill, much needed. But can you go over the penalty status on that bill again? Sure. I heard one of the DAs say life. So what are the penalties?
Well, I mean, it depends on the situation it is.
You have to classify.
Okay, but we're going to raise everything from a Class C misdemeanor, because to my just absolute,
That's ridiculous.
It's horrible. We've got a third-degree felony for 0 to 150,000, second-degree felony from 150 to 300,000. Above 300,000, it's first-degree felony. As I mentioned, this bill rocketed out 145 to 0 out of the House. If that's answers your question.
That sounds like.
I do, Mr. Chairman, want to ask the Texas Rangers if I could. There was a well-known case that y'all investigated, which was Harris County Commissioners Court. It was Elevate Strategies. You also investigated, I believe, this IBM case as well. I assume that if you only have a Class C misdemeanor to hang your hat on, it's very difficult to make a prosecution in a case, sir? Is that what?
Yes, sir, that is correct.
Okay. Would you like to expand upon what, in a future setting, okay, to go forward, using these type of felony charges for a 5-year statute of limitations would be a lot more successful building a prosecution case against someone that's clearly involved in bid rigging, for example?
Yes, sir, and committee members, without going too much into those investigations, because those are still open investigations, they have not been closed, even though the 4 charges have been dismissed. The allegations, it takes time for those allegations to come out and to provide supporting documents. So that investigation didn't initiate until end of September of 2024, and the statute of limitations ran on that by mid-November. So for a complex investigation to be concluded within a month or month and a half is very, very difficult. I've worked a number of financial investigations, and typically the time it takes to subpoena and gather search warrants, to gather documentation, which usually yields more subpoenas and search warrants, it just takes an extensive amount of time to put those complex investigations together and to bring them to fruition. So I do think enhancing the penalties and extending the statute of limitations would benefit on the investigative side.
And Major Wolf, I think the important point for everyone to understand is that if you have a very short statute of limitations, by the time you can find out what's going on, you're up against the shot clock, literally, to be able to put together a case and get it done before the statute of limitations expires. And there's been a lot of anecdotal evidence that people have seen in the public, like the emails between the former, county healthcare director and these companies. And I think they're just infuriated by what they see. But the problem is that without a high enough penalty and a long enough statute, having what I consider a positive lock on the investigation one way or the other, it is kind of elusive because of the shortness of the time. Is that a reasonable summary?
I believe it is, yes, sir.
Brent, you want to add to that?
No, I think you've captured the essence of it. You're fighting a long battle with a short stick.
Well, that's probably pretty good. Brian, anything else you want to add?
I concur with everything said.
Thank you.
Mr. Chairman.
Finish now.
Oh, sorry. I asked if you were done.
No,
So, okay.
you asked and you kept running. I think that's a great bill, much needed bill, and I would like to see them have more time on the statutes of limitations, because that is one of the problems that you run into in a situation like that, and it's highly needed. So, and proper penalties, and it sounds like you got them there. Sounds like you have a good bill.
Thank you, Senator.
Senator Hagenbu.
Thank you, Mr. Chairman. Senator Bencor, I think Mr. Middleton had suggested a potential modification or adjustment. Is that necessary, you think, or?
Well, I haven't had a chance to discuss it with DA, but we'll look at it. There's some, there's already at least reasonable definition of this. And I do understand the gap analysis, gap analogy, but I think there's a pretty good pecuniary definition that's used in common law. But I'm always listening to any DA that's willing to tackle this problem. And these are two of the best that will tackle this problem in the state of Texas, not counting the Rangers in between.
It's our partner.
That's right. You've got it, because somebody has to do the investigation.
Right.
Okay.
Any other questions, members? Thank you all for your testimony. Thank you for being here.
Thank you.
Thank you. Chair sees no one else for invited testimony. Invited testimony is now closed. Chair now opens for public testimony. There's no one registered to testify publicly. Is there anyone present wish to testify on, for, or against House Bill 2001? Hearing none, public testimony is closed, and we'll have the bill pending.
Thank you, Mr. Chairman and members. Thanks, Senator.
Okay.
There we go. Thank you, everybody.
Senator Hinojosa, could you?
The chair lays out House Bill 1866 and recognizes Chair Flores to explain the bill.
Thank you, Mr. Chairman. Members, House Bill 1866 by John Lujan focuses on protecting one of the Texas' most iconic and historically significant sites, the San Antonio Missions. While the National Park Service law enforcement rangers are tasked with protecting these federal park sites, their law enforcement powers are limited. Under current law, NPS rangers operate under federal authority and can enforce federal laws and regulations, but they are not recognized as peace officers under Texas law. This means that when a crime is committed that violates state law, like trespassing, vandalism, or drug offenses, the rangers cannot act independently. They must defer to local law enforcement, also often resulting in delays that allow offenders to slip through the cracks and missed law enforcement opportunities. House Bill 1866 modernizes and strengthens that framework, and it grants federally commissioned National Park Service Rangers Texas Peace Officer authority for crimes committed within the boundaries of the national parks or the national recreation areas in Texas. And with that, that's basically the bill.
Are there any questions of Chair Flores? Chairman Flores, and I see your light, Senator Vandercourt. Can somebody turn off that mic, please? Okay. Any question, members? If not, we'll open public testimony. I'm sorry, we'll open invited testimony. Do we have any invited testimony? I don't see any. We'll close invited testimony and open public testimony. Do we have anybody wish to testify? We have Seth Bell. Mr. Bell? Bell, just identify yourself, who you represent, and your position on the bill, and you have 2 minutes.
Thank you, Senator Hinojosa, Chairman Flores, and members of the committee. My name is Seth Bell. My paying job is as an attorney in San Antonio, but my volunteer job is as the board chairman of Mission Heritage Partners. For over 40 years, Mission Heritage Partners has been the official nonprofit fundraising and advocacy group for the San Antonio Missions National Historical Park. For those that are maybe unfamiliar with the San Antonio Missions, it is 4 non-contiguous sites comprising approximately 1,000 acres on the south side of San Antonio. That would be Mission San Jose, Mission San Juan, Mission Espada, and Mission Concepcion. In the interest of time, I do want to give a specific practical example that's recently happened just in the past few weeks in the park and how this bill would help. One of our national park officers stopped an individual at Mission San Juan. When he ran his credentials, he had multiple active warrants from Bexar County, including assault of a police officer. Under current law, the National Park Ranger cannot execute on that Bexar County warrant because they're federal law enforcement. That's what this law would change and allow them to do that. So the calls went out to San Antonio Police Department and the Bexar County Sheriff's Office to come and execute on this warrant. San Antonio Police Department immediately canceled, saying they were unable to respond. The Bexar County Sheriff's Office initially said they could not. Upon second call, an officer was able to respond from outside the city limits, approximately arriving about an hour later. Upon arresting this individual, he also had in possession of marijuana and had a loaded weapon in his car. So what this bill would change is that our officers would be able to assist local law enforcement in executing on that warrant and arresting that individual, because oftentimes when SAPD and Bexar County Sheriff's Office cannot respond, they have to let the person go. And this law would change it. It is widely, strongly supported by local law enforcement in San Antonio. Thank you, Chairman Flores, for carrying this bill in the Senate.
Thank you for your testimony. Any questions, members? I don't see any questions. We appreciate you coming up here to testify.
Thank you, sir.
Anybody else present would like to testify for, on, or against House Bill 1866? If not, public testimony is closed, and we'll leave the bill pending.
Thank you.
Next, we'll lay out House Bill 4996 and recognize Chairman Flores to explain the bill.
Thank you, Mr. Chairman. Members, public servants are highly susceptible to having fraudulent liens filed against them by citizens who are unsatisfied with a decision made by a public servant. When public servants such as judges, prosecutors, legislators, school officials, and correction officers are not protected while making decisions, fear of retaliation against those decisions can corrupt the deliberative process. House Bill 4996 seeks to deter this abuse of public servants by increasing the penalty for refusal to execute the release of a fraudulent lien or claim if the owner of the real or personal property subject to the fraudulent lien is a person the actor knows is a public servant. House Bill 4996 amends the Penal Code to increase the penalty for refusal to execute the release of a fraudulent lien or claim from a Class A misdemeanor to a third-degree felony if the owner of the real or personal property subject to the fraudulent lien or claim is a person the actor knows is a public servant. And with that, I open any questions.
Any questions of Chairman Flores? Chair here sees none. We will have invited testimony, but I don't see any witnesses registered for invited testimony, so we'll move on to open public testimony. And I don't see any witnesses registered to testify as public witnesses. So anybody present who would like to testify for, on, or against the House Bill 4996? If not, public testimony is closed, and we'll leave the bill pending.
Thank you, Mr. Chairman. say aye so much it sounds like a song. All right, members, we'll proceed with voting. Chair moves that House Bill 47 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
Aye.
Senator King, Senator Hagenbu.
Aye.
4 ayes, no nays.
4 ayes, 0 nays. House Bill 47 will be reported to the full Senate with a favorable recommendation.
Do we have any more local?
That one's not eligible because I think it's... Yes. Chair moves that House Bill 171 do not pass, but that the committee substitute for House Bill 171 adopted in lieu thereof be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu.
Aye.
4 ayes, no nays.
4 ayes, 0 nays. Committee substitute for House Bill 171 would be reported to the full Senate with a favorable recommendation. Senator Miles moves and recommends that the committee substitute for House Bill 171 would be recommended for a local non-contested calendar. Any objection? Hearing none, so ordered. Chair moves that House Bill 285 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
Aye.
Senator King, Senator Hagenbu. 4 ayes, no nays.
4 ayes, 0 nays. House Bill 285 will be reported to the full Senate with a favorable recommendation. This one's not eligible for... Chair moves that House Bill 305 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 4 ayes, no nays.
There be 4 ayes, 0 nays. House Bill 305 will be reported to the full Senate with a favorable recommendation. Senator Hagenbu recommends that House Bill 305 be recommended for local non-contested. Is there any objection? Hearing none, so ordered. Chair moves that House Bill 449 do not pass, but that the committee substitute for House Bill 449 adopted in lieu thereof be reported to the full Senate with a recommendation that it do pass favorably be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 4 ayes, no nays.
4 ayes, 0 nays. The committee substitute for House Bill 449 will be reported to the full Senate with a favorable recommendation. Chair moves that House Bill 908 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 4 ayes, no nays.
There be 4 ayes, 0 nays. House Bill 908 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa recommends House Bill 908 be recommended for local non-contested calendar. Any objection? Hearing none, so ordered. Chair moves that House Bill 1024 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes and 0 nays. House Bill 1024 will be reported to the full Senate with a favorable recommendation. Senator Hagenbu recommends House Bill 1024 be recommended for the local non-contested calendar, and any objection, hearing none, so ordered. Chair moves that House Bill 1306 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa, Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There'll be 5 ayes and 0 nays. House Bill 1306 will be reported to the full Senate with a favorable recommendation. Senator Miles recommends that House Bill 1306 be recommended for local and uncontested. Any objection? Hearing none, so ordered. Chair moves that House Bill 1443 be reported to the full Senate with a recommendation to do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu.
There be 5 ayes, 0 nays. House Bill 1443 will be reported to the full Senate with a favorable recommendation. Chair moves that House Bill 1445 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes and 0 nays. House Bill 1445 will be reported to the full Senate with a favorable recommendation. Senator King recommends that House Bill 1445 be re-recommended for local and uncontested. Is there any objection? Hearing none, so ordered. Chair moves that House Bill 1902 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There'll be 5 ayes, 0 nays. House Bill 1902 will be reported to the full Senate with a favorable recommendation. Chair moves that House Bill 2001 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There'll be 5 ayes, 0 nays. House Bill 2001 will be reported to the full Senate with a favorable recommendation. Chair moves that House Bill 2355 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
2355.
2355.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There'll be 5 ayes, 0 nays. House Bill 2355 will be reported to the full Senate with a favorable recommendation. So Senator King recommends House Bill 2355 be recommended for local and uncontested calendar. Is any objection? Hearing none, so ordered. Chair moves that House Bill 2492 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There'll be 5 ayes, 0 nays. House Bill 2492 will be reported to the full Senate with a favorable recommendation. Senator Hagenbu recommends that House Bill 2492 be recommended for local and uncontested calendar. Any objection? Hearing none, so ordered. Chair moves that House Bill 2637 do not pass, but that the committee substitute in lieu of be reported to the full Senate with the recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, oh, sorry, Senator King, Senator Hagenbu. 5 ayes, no nays.
Be 5 ayes, 0 nays. House committee substitute for House Bill 2637 will be reported to the full Senate with a favorable recommendation. Senator King recommends that House Bill 2637 be recommended for local and uncontested calendar. Any objection? Hearing none, so ordered. Chair moves that House Bill 2697 be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There'll be 5 ayes, 0 nays. House Bill 2697 will be reported to the full Senate with a favorable recommendation. Senator Hagenbu recommends House Bill 2697 be recommended for local and uncontested calendar. Any objection? Hearing none, so ordered. Chair moves that House Bill 3464 do not pass, but that the committee substitute for House Bill 3464 adopted in lieu thereof be reported to the full Senate with a recommendation that it do pass favorably and be printed. Clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There'll be 5 ayes, 0 nays. Committee substitute for House Bill 3464 will be reported to the full Senate with a favorable recommendation.
This one is fine. It was 2282. This one is okay.
Chair moves that House Bill 4263 do not pass, but that the committee substitute for House Bill 4263 adopted in lieu thereof be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There'll be 5 ayes, 0 nays. Committee substitute for House Bill 4263 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa recommends that the committee substitute for House Bill 4263 be recommended for local and uncontested. Any objection? Hearing none, so ordered. Chair moves that House Bill 5667 be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There'll be 5 ayes, 0 nays. House Bill 5667 will be reported to the full Senate with a favorable recommendation. And Senator Hagenbu recommends that House Bill 5667 be recommended for local and uncontested calendar. Any objection? Hearing none, so ordered. Yes. Chair moves that House Bill 2282 be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
Nay.
Senator King, Senator Hagenbu. 4 ayes, 1 nay.
There'll be 4 ayes and 1 nay. House Bill 2282 will be reported to the full Senate with a favorable recommendation. So I'll need to pass this over.
Mhm.
Senator Hinojosa, if you can read the two Flores ones.
Let's see.
Chair Flores moves. Chairman Flores moves that House Bill 1866 be reported to the Senate with recommendation to pass with printed. Clerk call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
Being 5 ayes, no nays, House Bill 1866 reported to the Senate with favorable recommendation. Chair Flores moves that House Bill 4996 be reported to the full Senate. Recommendation do pass and be printed. Clerk call the roll.
Okay. For 1866.
4996.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
Aye.
Senator King, Senator Hagenbu. 5 ayes, no nays.
There being 5 ayes, no nays, House Bill 4996 reported back to the full Senate with a favorable recommendation. Senator Miles moves, you want a local?
Yes.
Senator Miles moved that House Bill 4996 be placed on the local and uncontested calendar. Is there objection? The chair has now so ordered.
Oh,
do you want
that
to-
one can't because it's an increase in penalty. Yeah, that one can't.
All right.
Not eligible, but thanks for asking.
We will not recommend it to the local. I'll be before the full Senate floor. How about House Bill 1866?
That's good.
Senator Miles moved that House Bill 1866 be recommended to the local and uncontested calendar. Is there objection? Chair has no objection. It's so ordered.
Members, thank you very much for your patience and being here so early, and thanks for everyone who showed up so early and your testimony. And that concludes our business for today, and the committee stands in recess subject to the call of the chair.